we get to several other issues within this case. Many that I have with you all, and I know a lot of it stems from my situation with Judge Holder, former Judge Greg Holder, who falsely accused me of perjury, which we all know I won that case, and I'm in the process of appealing it to the 11th Circuit. But that's just a different issue. Another reason I think that this court, this whole entire jurisdiction, should be disqualified from dealing with me until we resolve that matter. Moving along, when it came to,
I don't know what you're talking about. So,
that's fine. That's fine.
so let's get to the point.
Okay, the point is no one other than the ARB made an appearance by rule under 1.720 for the mediation that brings us to where we are now, where you tried to enforce, or actually you didn't try, you ordered me to go and sign a release that had conditions that did not match what we discussed at the mediation conference. You had no jurisdiction over the unrepresented parties, and your order essentially foreclosed matters that were never pled to this court. The fraudulent inducement issue is an issue that did not have nothing to do with this court. When you said you wanted to release the parties, and that release had conditions we never discussed and never could discuss by rule. And it states real clearly, Florida law requires that all parties must, 10 days before mediation conference, file with the court a notice informing all parties who will attend the mediation conference. And then you go, unless stipulated by the parties, each party 10 days prior to appearing at a mediation conference shall file with the court and serve all parties a written notice identifying the person or persons who will be attending the mediation conference as a party representatives. And you can go to Alvarez versus Citizens Property Insurance Company, go 325 SO dot 3D 231, 234, and that's the Florida District Court of Appeal. And I'm going to stand on that. So hence, the amount of unethical conduct and attorneys disregard of their duty of candor, again, that doesn't apply to me. I'm not an attorney. I don't pretend to be one. Okay? I read. And candidly, the unethical conduct is one thing, but the court to sanction criminal behavior is almost mind blowing. And there's no rule, no law anywhere, nowhere where any court in Florida has ever allowed a court to take jurisdiction of parties that are not properly before the court. The mediation stipulation agreement, had it been just about the Tuckers, we wouldn't be having this discussion potentially, except for the fact that Michael Rowe's extrinsic fraud in calling a mediation conference when he knew that his underlying desire was to try to get everybody else absolved from their criminal conduct, to include, I think his name is Chavanik, with the Department of Veterans Affairs. I never spoke to this guy and didn't know that he was a VA attorney until after the mediation conference was settled. So I'm starting to find out that, okay, you all were just being unethical the whole dang time. Then I get in front of you, Judge Peacock, and when I argue with Michael Rowe, you stop just short of referring to him one of the most racially derogatory terms and tell me that I can't argue my case based on the facts that the court was aware of in your courtroom. So I'll again ask you to suspend, disqualify, or recuse yourself, because you also recuse yourself from an associated case because the same parties are involved, and I don't trust you to do the right thing at all, because you've already carried the water for Michael Rowe's unethical conduct, as well as that of